Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. Today we're continuing in our video series, which is designed, of course, to educate the viewing public on issues related to law, particularly family law. So please subscribe to our channel. Today we're going to talk about the general divorce in Michigan with respect to three specific things. We're going to talk about filing for divorce, the timeline for an overall divorce, and the divorce decree. In terms of filing for a divorce has to be filed in the county where one of the parties resides. If you've got parties that are separated and one's lived, for example, in Oakland County for 10 days or more, and the other one lives in Macomb County for 10 days or more, either one can file in either county, and it'll be essentially a race to the courthouse, whichever county you want to. Either one of those is a valid county. In a situation where the parties are still living together, of course, it should be filed in the county where the parties reside. In terms of the timeline, the court sets up sort of a schedule of events that occurs once someone files for divorce. The lifespan of a case is a little bit different with children versus no children. If a person files, for example, a divorce which we call a DO, a divorce where the case number ends in the suffix DO, a divorce without children, the timeline is much smaller. The court doesn't have to schedule front of the court things and all these things that relate to custody, parenting time, child support, because there are no children. So therefore, the timeline of that case is much, much smaller. The court will set up the scheduling on that basically over 60 days with the idea that after 60 days, the parties will be invited to finalize. If there are children, though, that spans to a 6-month waiting period. That means the schedule of events will occur within 6 months. You file in January, you cannot expect to finalize before June, July, because during that time, the court is going to have front of the court investigations, recommendations. It's going to deal with the issues regarding the children. And it's also leaving a little bit more time for the parties to reconsider their actions and maybe, who knows, even engage in discussions for reconciliation. Why? Because there's children. The court has less of an interest in reconciling relationships when there are no children. The court's general view is two adults get together, they decide they no longer want it, goodbye and good luck. There's no compelling reason to try and keep them together. With children, it's a different story, so the timeline is longer. Now, either way, whether you're in a divorce with children or not, you'll ultimately come to step 3, which is the divorce decree, or what lawyers call the judgment of divorce, the JOD. Either way, whether there's children or no children, whether there's a lot of property or a little property, you're not divorced until some judge signs a judgment of divorce. It could be default, it could be by consent, it could be by after a hearing or trial, but some judge has to sign an order, a divorce, which basically says you guys are no longer married. The objects of matrimony are now destroyed. The bounds of matrimony are cut. Now you can go off and remarry tomorrow if you want to. But you cannot do that unless there's a judgment of divorce signed. And what that truly means is, let's say, for example, in a weird case where you go through all the process, you do everything, you even have a trial. If there's no judgment of divorce signed, you're still married. You don't become actually divorced until the court signs its name on a judgment of divorce. It's filed with the clerk, it's stamped, copies are distributed to everybody, then you're divorced. Until that time, there's still that one step to do before it can be finalized. Now, if you have questions about your process or your divorce, reach out. Of course, we'll be glad to help you out.